more senior members of the arbitration community. Members of the CIARB may apply to participate in the mentoring program at the start of each new cycle. Mentor groups are formed of young mentees assigned to a mentor, a senior arbitration ADR expert, and a mentor supporter, an established practitioner. Mentor and mentor supporter will be available to provide the mentees with career guidance and arbitration ADR practical knowledge. The cycle will be 1 year, and the group can coordinate to develop a plan of activities aiming to develop relationship among the entire group, with potential activities like workshops, video conferences, publishing articles, sharing information, and networking opportunities. For more information, you can go to the link indicated in the slides. Regarding today's webinar, I request you to post your questions in the Q&A section and not in the chat box or the comments. We will take questions from the Q&A section only, as we expect to receive many questions, and we may not be able to answer all the questions. Questions with the largest number of votes will be answered at the end of the webinar. The introduction of the respected speakers will be somewhat different from the normal webinar, as the webinar will take a theme of simulation or a mock case of an arbitration, and therefore I humbly introduce myself first as the sole arbitrator. I am Mahmoud Nabil Sadani. I hold the double major degrees in construction engineering and in law. I earned a bachelor degree in construction engineering at Shams University and a master degree in construction law arbitration LLM Robert Golding. I am also a fellow Chartered Institute of Arbitrators, committee member as a membership officer of the CIARB Egypt branch. With us is Dr. Walid Al-Namr. Is well known to all the construction field in Egypt and others. He's a renowned speaker in many other seminars. Dr. Walid completed the PhD degree from the University of Salford. He completed his bachelor and master's degree in construction engineering from the American University in Cairo, as well as a master's degree in law with specialization in construction law and arbitration from Robert Gordon University. He is a fellow under the Chartered Institute of Arbitrators and the vice president of the Egypt branch. He is also a member of the Association of the Advancement of Coast Engineering International and president of the Egypt section, and is currently the vice president. He is also a certified mediator, and he is currently the director of Hill International Africa branch based in Egypt, and is an adjunct assistant professor in the construction engineering department of the American University. Dr. Walid, we are welcome. With us is a colleague, engineer Amr Askar. He holds the bachelor degree from civil engineering at Al-Azhar University. He is a certified environmental engineering specialist in American University in Cairo, certified the project management professional PMP, and a member of Chartered Institute of Arbitrators. He holds the master in construction law and arbitration LLM Robert Gordon University. His current job is the host country contracts manager CDM Smith. Welcome, Engineer Ram.
Thanks, Engineer.
Now there are two poll questions that we will need you to vote for. The first question is, did you encounter the situation where the variations are ordered by the employer after the contract completion date has elapsed? We're waiting for the poll question. Okay, now we can receive. Okay, more than 50% encountered such event. The second one, we would like to know the primary profession for the audience. An engineer, a lawyer, both, or other. Now we can choose. You can see the vote. %70 engineer, 15% lawyer, 7% both, and others are the rest. So the majority are engineers. Now we'll start the simulation and commence the hearing, and I will now wear the hat of the sole arbitrator. And Dr. Walid will be the claimant, and Mr. Engineer Amr will be the respondent. Thank you, Mr. Claimant. Thank you, Mr. Respondent, for attending the hearing dated 15th of August 2020. I would like to start with an outline brief on my opening statement. We will discuss the housekeeping, facts of the case, understanding of net versus gross theory, and hearing procedures. Submissions and communication. The arbitration comprises of a statement of claim submitted by the claimant and the statement of the defense submitted by respondent, and there were no counterclaims. All written submissions, hearing transcripts, orders, and awards generated during the course of the arbitration shall be deemed confidential. No fact or expert witness were required. Kindly direct your communication to the arbitrator. Please do not communicate directly with each other during the hearing. The sequence of the timing of the hearing shall be as follows. Claimant statement 15 minutes, respondent statement 15 minutes, arbitrator questions 10 minutes. Let me summarize the facts of the case as I understand them from your submissions. The commencement date, 1st of January 2019, which is the commencement of the works, maybe the commencement of the contract. Contract completion date, 28th of November 2019. This is the contractual completion date. However, the actual completion date is 1st of April 2020. That means that the works delayed till 1st of April 2020. However, there was a variation issued on 14th of Feb 2020 and took a duration of 14 days till 28th of February 2020. The respondent issued an extension of time till 12th of December 2019, which is 14 days from the contractual completion date, 28th of November 2019. From here to here, as you can see. Please confirm my understanding.
You're correct, Your Honor. I have no comments. Thank you.
Thank you.
Yes, that is the truth. There is no comment.
Thank you. Now, from your submission, I understand that the core of the dispute lies in what you refer to as gross and net theories or methods for the extension of time. Is this also correct?
That's correct, yes.
Yes, that's correct.
I will summarize my understanding as that the gross theory means that the extension of time is equal to the date of the variation instruction plus the duration of the execution of variation, noting that there will be, this is a simple event with no other remaining works. So the extension of time will be 28th of February 2020. Here is from your submissions. I extracted this flow chart showing that the works contractual date is 28th of November, and this is the extension of time. However, this is the date of the instruction of the variation till 14 days. Then this is the extension of time required, and therefore till the TOC taking over certificate, which is الاستلام الابتدائي. This will be the applied LDs under the gross theory. However, in the net theory, the extension of time means the contract completion date, it's the original contractual date, plus the duration of the execution of a variation, of the variation structure. This will mean that extension of time will be till 12th of December 2019. Another extract from your submissions. This is the contractual date. This is the duration of the variation, of the execution of the variation. And this is the LDs that will be applied due to such theory.
Yes, I'm confirming that. Yes, I'm confirming that.
Okay. So this is just comparison as a quick glimpse. This is the LD which will be required under the gross theory, and this will be the LDs under the net theory. Here is from the date of issuance of the variation till the execution, and this is ignoring the variation issuance date and calculating the extension of time from the contractual completion date. Please, can you confirm, please, Dr. Walid also, Mr. Claimant?
Your understanding is correct, Your Honor. Yes.
Thank you. Now I leave the floor to the claimant to demonstrate his submission.
Thank you, Mr. Arbiter. Can you please stop sharing your screen so I can share my screen? Yes, thank you. Thank you, Your Honor. I would first like to start my presentation by summarizing really the key points in my submissions, and which all revolve around the premise that there are very essential defects in the net theory which render it not really applicable, not contractual, not even legal for the extension of time that I was granted, and therefore the liquidated damages that were applied. And these defects that I will go through in this presentation this evening are comprised of the following. First of all, that the net theory does not take into account the employer's delay of not processing the EOT claim, my extension of time claim. The second is the retrospective application of liquidated damages that leads to the lack of prospective certainty, which is essential in our contract and all other contracts. Third is that the net theory destroys the contractual relationship between a variation and the work. Fourth, that it breaches or it violates the good faith principle that is enshrined in the law and in the contract. And last point is that the extension of time granted under the net theory does not make any practical or commercial sense. Now I will start with the first point about the respondent's delay in processing the claim. And in that regard, Your Honor, I'd like to highlight that whereas I fully agree with the facts of the case that you've presented, however, there is just one fact that that was not presented, which I'll just present now, which is of course critical for this case, which is that on the 10th of November, I submitted an extension of time claim that is covers all the delays that I've encountered from the employer in the project, and that as of this date of this hearing, I was not presented with the employer's evaluation of this claim. Now, the basis of any net theory is that the contractor is in delay at the time of the contractual completion date. So in essence, as you've summarized, the contractor is in completion, is in delay before the contract completion date, then he's in delay after the contract completion date, a variation is issued, and then since the variation is an excusable delay, it's something that the contractor is entitled to an extension of time for. So the contractor is only given the duration of that variation. Now, that is with an assumption, Your Honor, that that all the delays were due to the contractor. Now, the question here is, if isn't an engineer or employer's delay in processing a claim of similar effect to that of any employer delays? So if I submit a claim, as I have in this case, Your Honor, and I do not get any response from the employer or the engineer, of course, doesn't that amount to a delay? And now if you look at our contract in clause 8.5, which really lists the causes that entitled a contractor to an extension of time, we will find, Your Honor, that there are several factors. Of course, there is the variation, there is a cause of delay giving an entitlement under the conditions that is expressly in the conditions. There is, of course, exceptionally adverse climatic conditions. There are unforeseeable shortages in the availability of personnel or goods. But there is this clause, Your Honor, which is any delay, impediment, or prevention caused or attributable to the employer or the employer's personnel. And let's not forget that one of the employer's personnel is the engineer. So the question really here, Your Honor, is that, or the statement here, the conclusion is that an engineer's delay in processing a claim before the contract completion date, Your Honor, is definitely an impediment. Had I known what the engineer's processing of the claim, if the engineer rejected my claim or accepted a part of it, had I known that promptly before the contract completion date, promptly after I submitted my claim, that could have affected how I'm proceeding with the work. It could have affected how I'm using my resources. However, this did not happen, Your Honor, and that's why I submit this is definitely an impediment, and which should be taken into account when processing the extension of time, and which I believe affects the application of the net theory. And the second point, Your Honor, is lack of prospective certainty. Now let me clarify what do I mean by this term. So the intent of the parties in any contract form, not just the FIDIC form, is as follows. First of all, a time for completion is defined in the contract. The parties agree what the completion date is going to be. So in this case, in the FIDIC 2017, it's in subclause 8.2. The contractor submits a program or a time schedule that demonstrates how the contractor will achieve this time for completion, and that is in subclause 8.3. Then if the contractor encounters circumstances or causes that call for an extension of time, then the contractor can submit a claim, an extension of time claim. There's a mechanism in the contract where the claim is submitted, the claim is reviewed, extension of time is granted or rejected, and then but then the contractor knows what the completion date is. And then if the contractor does not achieve the completion date of the project, then and only then would liquidated damages be applied, and that is in subclause 8.8. So in other words, Your Honor, what am I trying to say here? Now, the contractor, which is represented here, who is represented here by this I, always has in front of him the contract completion date. The contractor is always aware that the contract completion date is in the future. He sees it in front of him. He can plan accordingly, and therefore, that is what I mean by prospective certainty. So prospective because that's something in the future, and certainty because it is something that is, the contractor is certain about what the completion date is. So that's why that's crucial in any construction contract, Your Honor, that the contractor knows and can plan accordingly for the contract completion date. So what happens in the net theory as applied in this case? In the net method, the contract completion date has lapsed, and then the contractor is instructed to implement a variation, and the contractor implements this variation, and then the project is completed. And then the extension of time, the determination for the extension of time that the contractor had submitted prior to the contractual completion date is now after the project is completed or prior to that. Of course, I can say prior or maybe after the contract, the completion date is the project is actually completed, or sometimes before that. However, the most important thing, way after the variation is completed, then the claim is determined, and the contractor is surprised to know that the completion date is way in the past. So the contractor had no idea what the completion date was at the time of performing this variation. So in other words, the contractor in this case, what he sees in front of him really is nothing but the unknown. There's nothing for the contractor is really working in the dark. And what has passed behind him is actually the contract completion date, and that, I submit, Your Honor, negates the intent of the contract, the intent of the parties of prospective certainty, and therefore that's why the application of the net theory, Your Honor, I submit, is not correct, and it's not correct construction practice. It was not the intent of the parties. The third point I want to raise, Your Honor, is that the relationship between the term variations and the work. And if we look at the definition of variations and work in our contract, you'll find that variations means any change to the works which is instructed as a variation. I emphasize here, Your Honor, any change to the works. So therefore, a variation is part of the works. It cannot be separated from the works. So in other words, if variations are part of the works and a variation is ordered after the contract completion date, then the works would not be considered complete, Your Honor, until the variation and its effects are completed. And let's remember here one thing, that this variation is, that's the variation being ordered late. That's not because of the contractor. That's because of the employer. The employer just remembered weeks after the contract completion date that there was a piece of the work, a part of the work that the owner wants to implement, and it is so essential that the employer would not issue a taking over certificate to the contractor until this work is done. So that's not really the fault of the contractor. If had the employer really, if that variation was essential for the works, why wouldn't the employer remember to issue this variation before the contract completion date? So this, by choosing to instruct a variation months or weeks after the contract completion date, the owner has effectively extended the scope of work in the contract. And if he extended the scope of work in the contract, we know that the contractual, that the time for completion is related to the works, the completion of the works. Therefore, the employer made a conscious decision to extend the works of the contract and therefore extend the time for completion of the contracts, and therefore should not apply damages after that extended works. And that, of course, is a negation of the net theory, because the net theory attempts to segregate this variation and the variation and the works. It attempts to put the carriage before the horse. So an employer's need for a variation after the completion date is an indication, Your Honor, that the employer was not really ready to take over the work at the contract completion date. So let's assume that I had completed, I was on time, and I had finished on the 28th of November. And then would the employer, would he have made beneficial use of the project? He would not have, because that missing part of the work, that variation work, was not there. So he would still have waited until that variation was ordered. And that actually takes me to an important legal argument, Your Honor, which is, if we look at the Egyptian Civil Code, Article 224, you'll find that damages fixed by agreement or liquidated damages would not be due if the debtor establishes that the creditor has not suffered any loss. And I submit, Your Honor, so in that case, by ordering this variation late, then the employer on the 28th of November had not suffered any loss, because he would have wanted that variation done anyway, and it would have been done weeks after the contract completion date, and therefore he did not suffer any loss. He was not going to use the works anyway until this variation was done. And that late decision to issue that variation, that's not the contractor's fault, that's the employer's fault, and the extension of time should be granted to cover the works. That's the intent in the contract, that's the intent of the parties, and that should be respected. Now, and it's very important, the application of the net theory or liquidated damages are applied on the contract completion date when the employer was not really affected yet at the contract completion date on the 28th of November. He was not really affected by this a lack of the variation, lack of ordering this variation, then that can, if we apply damages on the contract, the extended contract completion date until December, any date before that variation, before the works really are completed by the variation, then that is problematic, Your Honor, as that conflicts with this ECC provision, with this Egyptian Civil Code provision. The employer did not suffer any loss, and therefore that should be taken into account. Now, the fourth point that I want to mention is about the violation of good faith. And as we all know, Your Honor, that good faith is enshrined in the Egyptian Civil Code by Article 148. It's also in a lot of civil codes around the world. And in Egypt, Article 148 mentions that a contract must be performed in accordance with its contents and in compliance with the requirements of good faith, and that the contract binds the contracting party not only regarding the express conditions, but as a sequel to the contract, there are the law, usage, al-urf, and equity, fairness. So actually, all these are deemed to be a sequel of the contract. So it's not just, we're not just looking at the contract conditions, we are looking at all these factors put into place. And so good faith, fairness plays an important part. Now, in our contract, we have a new provision in the FIDIC 2017, which is the 8.4 advance warning, where the parties and the engineer all have they have an obligation, a common obligation, which is to warn each other in advance about a possible adverse circumstances that may affect the work of the contractor's personnel, the performance of the works, something that will increase the contract price or the time. So that, Your Honor, this advance warning is really a form of good faith. So it's like FIDIC has really paid attention to this concept of good faith and made it an integral part of the contract. So whereas it was in the Egyptian civil law all along as a mandatory obligation, now it's a contractual obligation. So good faith is important in both contract and the law. Now, moving on from that principle of good faith, there's the delayed damages clause in the contract, clause 8.8, which obligates the employer to comply with the claim provisions in the contract 20.2. And as we know, the 20.2 has a time bar where the contractor and the employer equally would lose their rights if they do not comply with the notice and detailed particulars provisions in the contract, with the notice in particular. So in that case, if the employer wants to apply liquidated damages, the employer must present a notice to the contractor that I will apply liquidated damages, and which did not happen in this project. And that, by the way, Your Honor, actually supports my understanding of prospective certainty. Now, having discussed good faith and having discussed the requirement for a notice under the contract for applying liquidated damages, let me take you, Your Honor, back to February, where the change was ordered. And in this project, we have a variation order form, and that form is comprised of several aspects. However, what I show here in the screen, Your Honor, is part of this variation order form, which is present in a lot of variation order forms. It has a tracking of the variations and the effects on the price of the contract and on the time of the contract. And if we look at the time component, Your Honor, you'll find that it has the original contract completion date, the approved previous extensions, Your Honor, and I underline here the word previous, and then the approved extension of time for the change order, this variation, and then the revised contract completion date. Now let's assume we're back in February, Your Honor, and I'm presented with this form, and the net theory is applied. So what happens, Your Honor, is that according to the net theory, this slot right here, revised completion date, and now, of course, we are in February, so this slot would, 1 second, Your Honor. This slot would yield a completion date, a revised contract completion date that is in the past, that is December. So I'm here in February on the field, going to implement a change, and I know, and the employer is presenting me with a form that the completion date, the revised completion date is December. So how would I react to this, Your Honor? I would definitely take an action. I would definitely reject maybe the variation. I would at least protest this decision. I would understand the intent of the employer to apply damages. So this really, Your Honor, raises a point. Now that we've discussed good faith and we've discussed the requirement for a notice for liquidated damages, and I really want to ask the following questions. Number one, is it in line with good faith required by law and by contract that the employer waits until the variation is completed and does not reveal the extended completion date that is in the past? This is like a form of concealment, Your Honor. And in doing so, doesn't this amount to tricking the contractor? And by the variation being completed and the employer having the benefit of the variation and then applying damages after that, doesn't this amount to unjust enrichment?
Objection. What do you mean by tricking? Also, there is no unjust enrichment. There is a contract here.
I'm sorry. So what else would you call it?
Order, please, order. Kindly remember the ground rules of the hearing. Kindly do not communicate to each other. Kindly direct your communication to the arbitrator. Please proceed, Mr. Claimant.
Thank you, Your Honor. The last point that I really wanted to mention was that the application of the net theory really negates common sense in practice, Your Honor. And I will just present this by very few simple points and facts that we should consider. Number one, the completion date of the project was 28th of November. This is the contract completion date that we have agreed upon. The variation date was 14th of February 2020. The variation was completed on the 28th of February 2020. And the response to my extension of time, the extended completion date, and I put an extended in quotes, is 12th of December 2019. Now the question, Your Honor, does this make any sense? Now, of course, if I'm asking this question, we should take into account that there may be forensic delay analysts, forensic planners, arbitrators, with all respect to you, Your Honor, judges, lawyers who would be opening up this case after the project is completed. They would look at paperwork and they treat this project as like a group of activities, and they would apply all theoretical methods to measure, to assess whether damages are applied or not, and the delay. However, let us consider what's happening in the field, Your Honor. When we are in the field and the contractor performs a variation in February, and the contractor knows then that is informed that the extended completion date is in December, that, Your Honor, does not make any practical sense whatsoever, and it should have been concealed and known to the contractor from the very start. And with that, Your Honor, I conclude my presentation, and I thank you very, very much for your attention.
Thank you, Mr. Claimant. Mr. Respondent, the floor is yours.
Hold on to share my screen. Is it appear now?
Yes, I can see it.
Yes. Proceed. Thank you.
Sorry for appearing like a ghost in the camera during two IT issues.
Okay.
My defense includes 5 points by using the same sequence applying by the claimant, mainly about defects in the growth theory, which includes alleged employer delay in processing contractor claim. Second, defense against lack of prospective certainty. Third, defense against variation extension of the work. Fourth, defense for the breach of good faith principle. Fifth and last point, net theory is considered fair and reasonable. Point 1, alleged employer delay in processing contractor claim. This point of defense is dedicated for the extension of time claim submitted before the contractual completion date. We shall ask ourselves here, did the claimant abide by the contractual procedures when submitting his claim? Also, what are the contractual consequences of such failure. As you see here, Mr. Respectable Arbitrator, the contractor is entitled to extension of time subject to following the procedures under subclause 20.2. But did the claimant abide by these procedures? The contractor has submitted his notice of claim lately, not according to the time bar stipulated under the contract, which is a condition precedent that must be fulfilled before granting an extension of time. Therefore, the time for completion shall not be extended pursuant to subclause 20.2. In fact, the claimant waited until the end of the project, last minute, to release his detailed claim for events that its impact lapsed since 6 months, which is completely impractical, even without considering the time bar provisions under the contract. The claimant alleged that the engineer has not responded to the claim. However, the engineering silence means the claim is rejected pursuant to subclause 3.7. In light of these facts, I'm requesting from the respectable arbitrator to waive the claimant entitlement related to this issue. Now, we move to the second point, defense against lack of prospective certainty. I will recall that my defense from this point to the fifth point is dedicated for the late variation issue. The claimant was emphasizing in his statement about prospective certainty philosophy. But the prospective certainty has no basis under the law. As a proof of this, the claimant did not refer to any legal reference for this point. The effect of applying the gross method alleged by the claimant, it wipes out all the claimant culpable delay, specifically 2.5 months, all delay between the contract completion date and the date of issuing this late variation order, by turning all delay to that point without paying attention to who is accountable for the occurred delay. Frankly, Mr. Arbitrator, applying the gross method approach is not considered fair and reasonable. The Egyptian Civil Code under Article 148(2) stated, a contract binds the contracting party not only as regard its expressed condition, but also as regard everything which according to law usage. Again, law usage, al-urf. Therefore, for guidance and to comply with the international construction standard usage, we'll cite here a similar British case, Palford Petty, concerning the same debate, net versus gross approach, which concluded by applying the net approach by the Court of Appeal, pertinent to the similar facts presented in our case here. In addition, I'm citing the Society of Construction Law Protocol, 2nd edition, released in February 2017, which is a significant international guidance for determining extensions of time and the compensation for delay and disruption. As shown, Mr. Respectable Arbitrator, the contractor delay in such a situation is not exonerated, and any extension of time should be simply added to the contract completion date. Again, is not exonerated, and any extension of time should simply be added to the contract completion date. In other words, the 14 days to execute this late variation order shall be added to the contract completion date, 28th of November, 2019. Also, I will go to Robert Knowles, who is a very well-known author in his well-known book, 200 Contractual Problems and Their Solutions, 3rd edition, specifically page 130, who refer to this dilemma and uphold applying the net approach by extending the completion date by the net period of delay. As you see, respectable arbitrator, applying the net approach in this situation is an international construction standard. Third point, defense against variation extended the work. I'm admitting here that the respondent late request for additional finishing work is a variation order. But the claimant logic that the work are not complete until the variations are completed, frankly, is not accepted, as it have neither a contractual nor legal reference. For guidance and to comply with the international construction standard usage also, we'll cite here a very famous similar British case, Hampbrook 1992, concerning the same debate, net versus gross approach. In this case, it was wrongly assumed by the contractor one worker was performing one-day work pertinent to late variation order, the contractual completion date to be extended to that day. In this case, the tribunal, as the Court of Appeal final decision, affirmed that the extension of time due should be added to the contractual completion date, which is complied with the respondent request to extend the contractual completion date to 12th of December 2019 only. The claimant referred to the Egyptian Civil Code, Article 224, which stated clearly, damages fixed by agreement are not due if the claimant establishes that the respondent has not suffered any losses, but without presenting any evidence for no losses. Again, without presenting any evidence for no losses. In fact, I suffered from significant damages due to the claimant failure to achieve the original completion date on 28th of November 2019, which is including but not limited to missing the official ceremony for the mall opening during the new year 2020. I lost huge revenue here. Low rent rate from the tenants due to losing the peak purchasing season as per the leasing contract conditions. Some tenants revoked the leasing agreement, and I'm still trying to find a replacer until now. Also, I'm paying salaries for the hired mall operation since the original completion date. For example, the operation manager, facility management team, security and marketing teams, and others. And for sure, paying the additional fees for the site project management and supervision consultancy services. After all of that, Mr. Respectable Arbitrator, do you have any doubt that I suffered no losses? This late variation order is not indication for the employer unpreparedness to take over the works. As you said, Mr. Respectable Arbitrator, the arbitration process is confidential, so I will disclose that. This late variation order issued only to draw the tenant's attention for improving the finishing works, as the mall is targeting type A customers, instead of focusing on the failure to achieve the completion date and to avoid further claims from their side. However, the claimant may not benefit from challenging the agreed liquidated damages amount by applying the net approach, which could entitle the respondent to sue for his general or unliquidated damages relief in the statement of defense that's submitted to you, Mr. Respectable Arbitrator, for the actual damages suffered, which will exceed the liquidated damages ceiling amount by far. By the way, this could be easily proved in this case. Fourth point, defense for breach of good faith principle. Despite I have a right to hand over the site to the contractor until receiving the performance security bond or the performance letter of guarantee pursuant to subclause 2.1, but I gave him such position even 3 weeks before receiving the performance security bond. Have released the amount due for every interim statement before the contractual deadline. Frankly, and sometimes within 7 days from receiving the payment certificate itself. Also, when the contractual completion date has lapsed on 28th of November 2019, and the claimant was already in culpable delay due to his fault. I'm saying again, due to his fault. I have decided not to enforce my right immediately, pertinent to applying the contractual liquidated damages to avoid the financial failure risk, which might be caused by this immediate deduction on the contractor cash flow. After all of that, I completely reject the claimant allegation for breach of good faith, as it is entirely baseless. Now we move to the 5th point, my last point of defense. Applying the net theory is considered fair and reasonable, as applying the growth theory would provide the claimant with unexpected gain, which wipes out all his culpable delay, again, 2.5 months before the issuance of the respondent late variation order. As explained, this employer late variation order is directly related to the delay of the claimant. If works were completed on time, the need of the variation order would have been identified earlier, which does not entail the invalidity of the contractual procedure. However, at the end of my statement, I understand the claimant argument, as it may not make sense, pertinent to the chronology of events, to extend the completion date to a point of time before instructing the employer late variation order, or with retrospective effect. But would like to draw the respectable arbitrator attention to the very famous British case, Carillon Construction, where the judge there acknowledged that, I'm quoting his words, even if it's against the commercial common sense to apply the net theory, but it is still the right approach to be applied in the construction industry. Again, even if it is against the commercial common sense to apply the net theory, but it is still the right approach to be applied in the construction industry. Therefore, my argument has a base. And I'm requesting from the respectable arbitrator to acknowledge applying the liquidated damages deduction from 12th of December 2019 by using the net theory approach. Thanks a lot, Mr. Respectable Arbitrator, for your time.
Thank you. Can you give me the screen, please? So, thank you, Mr. Claimant and Mr. Respondent, for your well-identified presentation. I have 2 questions before going to the Q&A. First question to Mr. Claimant. As I understood from the submission, in the construction, an extension of time is granted for excusable delays. Delays not attributable to the contractor. Do you consider the gross method to support the granting of extensions of time for non-excusable delays, delays caused by the contractor?
Your Honor, of course, I understand this argument, and yes, I can see the logic in this argument that since I was, my progress was slow before the contract completion date and after the completion date until the variation was ordered. However, as I mentioned in my presentation, let's not forget that there are two forms of delays from the employer. And the first one is that the employer did not, and his engineer did not process my claim promptly, and I submit that that is a form of delay, even if it is rejected in the contract. If there's no response, I'm owed a response by the employer. So that is a form of delay. I was not in, that's a delay from the employer. It's not purely on the contractor. The second thing is by the employers remembering to issue this late variation that extended the work scope of works, and therefore that should be the responsibility of the employer. It's not up to the employer to remember whenever he desires there's a variation, and to hold the issuance of the taking over certificate until this variation is issued because of his late remembering of this variation. So that those two factors are, I submit, an employer delays, which I would say actually would extend the project until the actual completion date of the project. In addition to that, Your Honor, I would like to emphasize that this issue is not the matter of dispute in this case is not just about net versus gross in terms of just culpable delays or not, but let's not forget the good faith factor, the legal factor here, which governs all contract procedures. And I submit that concealing this, the respondent's intentions and applying damages on a retrospective date that I had no idea about at the time of performing the variation, I believe that has a legal impact, and that definitely takes into governs this issue of that's raised in this question here about just the matter of excusable versus non-excusable delays. That should be taken into account, Your Honor. Thank you.
Okay, thank you. Second question for the respondent. You refer to the British case of Carillion construction to conclude that the net theory may not make commercial sense, but it is the fair and reasonable option. Is this an admittance that it doesn't make practical sense, as the claimant alleges in his submissions and presentation?
Let me say that, Mr. Respectable Arbitrator, practical sense is a difference than commercial sense. However, I will recall the judge's words. Even if against the commercial common sense to apply the net theory, but it is still the right approach to be applied in the construction industry. That means even if, okay, even if it is against the commercial sense. However, he still insists to apply the net theory in the construction industry when solving such a claim, to avoid providing the claimant with unexpected gain, which wipes out all of his culpable delay before issuing the respondent late variation on 14th of February 2019. In 14th of February 2020. For such, I'm still insisting to apply the net theory when solving this claim. Thanks a lot.
Okay. Thank you, Mr. Respondent. Thank you, Mr. Claimant. Thank you, Mr. Respondent. By this, I end the hearing, and you should be informed that I will render the award on 16th of September 2020, 30 days from now. And I will issue this formally to you both as per the procedure order number 3. The hearing is now adjourned. Now I remove the hat of the arbitrator and revert back to the moderating this webinar. Now, before I open the floor to the questions, I want to ask the audience the following questions, and I want you to participate in voting. First question: which contracting party are you currently affiliated with? Contractor, project management manager or consultant, employer, or other? Okay. And now? Okay. 46% the contractor, project manager and consultant 31%, employer 15%, and others 8%. The second one, which method do you feel inclined towards after this webinar, net or gross? This will be interesting. Okay. Net 60%, gross 40%. Okay, so from the percentages I can see that the project manager and employer 31% and 15% is almost 40%, which is the the percent of the gross theory. So I think that the project managers, consultant, and employers choose the gross method against the net method applied by the contractors, and others, I think, there will be the lawyers. Okay. Now I open the floor for the questions that will be in the Q&A section.
Bashwans Mahmoud, I would request Bashwans Amr, if you can now reveal yourself, because the ghost thing is now taken absolute form. If you can we can show yourself now with no background,
Okay.
probably, so that we can, yes. Welcome.
Thank you.
Okay. Thank you.
Right. Now we'll see this. Type. The most voted question, I think we can direct to Dr. Walid. Can you relate the time at large concept application in the scenario presented, since the extension of time was not granted for additional variation works? Secondly, if a variation was confirmed post contract completion date, should this be subject of a new contract, and or a contractor can refuse to undertake the variation as part of the original works?
That's a good question. Of course, the fact that the contract completion date has lapsed and there was no contractual date before that. For example, there was no response to the contractor's claim. There was no extension of time. In that case, by the UK sense, the time is at large. In Egypt, there's no time at large concept, but still, you can say the completion date is undefined. Now, and that's what, of course, an argument the contractor would argue is, I'd say, for example, in 1st of December, we would say there is no contract completion date. However, by the time the variation is issued, bear in mind that the taking over certificate was not, the contract is still in place until the TOC, the taking over, not actually until the defects notification period takes place after the TOC and the performance certificate is issued, which is the final completion certificate. So until then, the contract is still intact. So we do not have to go into a new contract for the variation. The variation is still part of the contract. Can the contractor refuse to perform? Actually, what the FIDIC contract says is once a taking over certificate is issued and the employer orders a variation after the taking over certificate. So in our case, if say the employer decides to order a variation in June, for example, in that case, the contractor may contractually say, I'm sorry, during the defects notification period, I do not have to perform any variation. But before that, so before 1st of April, the contractor is obligated to perform that variation, even if the contractor protests the application of damages or uses the gross theory to negate the net theory.
I'm upholding also Dr. Walid's words here. I will add only one thing, that is the contractor may also refuse to perform the variation order before issuing the taking over certificate, but with condition to be according to the provision of the contract. Like in 2017, if the product is off shelf, or it is against the governmental procedures, or there is 4 points is dedicated in 2017 for this issue. If he alleged and succeed to allege with this point, then he could refrain from making the variation order.
Dr. Reed, I want to ask a sub-question here. Can we differentiate between a variation order which is substantial for the completion of the works and additional works that is not substantial for completing the works? Can the contractor refuse in such case?
I don't believe a contractor can refuse, because whether it's an addition or not, whether it's essential for the works or not, it's still a variation according to the definition in 13.1. And whether it's substantial or not really is it's really the employer's prerogative. So it's the employer who decides. However, what a contractor can propose, say that the contractor thinks that it may not be substantial for the work, for example. Then what the contractor should do is the contractor can say to, why don't you issue taking over certificate, and I will do this insignificant variation work as part of the defects notification period, for example. This would be a good compromise. Give me the TOC, give me the taking over certificate, and let me do this insignificant variation during the defects notification period. And that's a win-win situation. Both parties would be happy.
Okay. Yes. A question for Engineer Amr. What if the contractor requested the determination of a revised contract completion date, extension of time, before accepting to proceed with the variation?
I'm sorry, may you repeat your words again? I'm sorry.
What if the contractor requested the determination of a revised contract completion date, extension of time, before accepting to proceed with the variation order?
Frankly, the contract is not entitling him to do that. But always, my recommendation to the employer, when he issuing a late variation order, to inform the contractor with the new completion date, even if it will be with retrospective approach. But he shall tell the contractor to avoid any kind of doubt. But the contractor cannot say, I'm not going to do that. Okay?
Okay. Dr. Walid, do you have any?
No, I don't have any comments.
Okay. Right. Another question that I may direct to Engineer Amr. Could the owner or the contractor refer to any clause in FIDIC or SCL which does not exist in the signed contract?
Look, he can. Look, he cannot refer to provision in other contract. Okay, but if there is nothing in the contract itself to speak about this dilemma, he can refer to the international standard, like the SCL protocol, as a tool to try to convince the employer with the contractor position, nothing else.
Okay.
Do you have to add anything, Dr. Walid?
Yeah, I was just going to say that when the contractor does that, of course, the question mentioned FIDIC, but let's remember that FIDIC is the contract in this case. But let's say if it's SCL or if it's AACE or any other standard, it's always encouraging for contractors to I think it was the question, I think, was for the employer, right? So the employer, it's beneficial for the employer to refer to that, because as Engineer Amr mentioned, it just shows what the international standards are saying. But when the employer makes these references, he should just know that it's not mulzima, it's not obligatory, it's not at the same level as the contract itself. That's the, I think, the distinction.
Okay, thank you. Mr. Hussein Gaber, I think it all depends. This is a statement, you can either respond. I think it all depends upon the nature of the VO and whether or not the works could have been taken over at the time of the completion. Prospective certainty, I believe the contractor should receive a response to its request so that it may carry out a cost analysis between adding resources to meet original time for completion and paying the LDs. This mechanism is similar to implementing acceleration so that the mechanism goes both ways. Please comment on the above.
May I start before Dr. Walid starts?
Sure, go ahead.
Look, Dr. Walid, he has written many papers in this issue concerning the prospective certainty, which is frankly was very useful. The audience statement here in relation to the prospective certainty is going at the same line. Really, the prospective certainty always give the contractual completion, the extension for the contractual completion date in the future. That is, the contractor can see and also to apply the fast track or the crash approach, okay, which is going with Dr. Walid way and is going also with the gross approach. Dr. Walid can add more words on that.
Yeah, I just want to say, first of all, the question mentioned, I just want to see it here, that it all depends on the nature of the VO and whether or not the works could have been taken over, the time for completion. Of course, in our example, the nature of the VO is such that it was essential, that it had to be performed, these finishing works had to be performed, or the employer would not issue a taking over certificate. So that means that it's really essential. If it's not essential, as we mentioned in the previous question, then the contractor can raise a suggestion of, let me do this VO in the as part of the snag list, and do not penalize me for this issue. The second point regarding, I fully agree with what you mentioned about the prospective certainty. I think that's very important, and of course, as you all know, the majority of my experience is really with project managers and employers. So, but I feel very sympathetic to contractors in that regard, because as you mentioned in the question, if the contractor knows and the contractor can make an analysis and assessment between the costs of the LDs and the costs of getting acceleration, and actually in one of the papers that Engineer Amr referred to, one of the projects that I experienced, the contractor was notified. There was a claim. We gave an engineer determination. There was 4 months left to the completion date with that engineer determination, which the contractor objected to, did not agree with. However, in the progress meetings, we would tell the contractor, 4 months, 3 months are left, 4 weeks are left. So this contractor, who was a Turkish contractor, actually, he took measures. He actually, he brought in laborers from Turkey, Imala from Turkey, to complete the project. Can you imagine? And he actually managed to complete the project in the determined completion date, which he objected to. And another project, such as like this one, in this case, the contractor had no idea what the completion date is, so the contractor did not take any measures. Actually, the contractor was practically, I want to say, very persistent with the contractor. Please, and not just respond to my claims, please give me a taking over certificate. He finished the works, and برضو a TOC would not be issued. And as a result, the contractor was like bleeding slowly, and it's not really, the project took time to complete and had no prospective certainty whatsoever. So I completely agree with what you mentioned, that Farhan, the contractor can take measures had the contractor would have prospective certainty. And including, of course, like you mentioned, the cost assessment between liquidated damages and taking acceleration measures, for example. Yes.
By the way, I will add also to Dr. Walid's respectable words the following: the net approach is not going with that. For being a contractor who has overshot the contractual completion date, and is in a notable delay, is praying by what you are going to say, is praying for such late variation order to mitigate his weak position. Therefore, he takes this employer late variation and argues that it abolishes all of his culpable delay by turning all delay to the point without paying attention to who is accountable for the occurred delay. And for sure, he will request then from the employer to not levy the liquidated damages during the contractor entire culpable delay period up to the date of issuing this late variation order, plus also sufficient time to perform the extra work. For such, the net approach is opposing to the prospective certainty. Okay.
I also want to add something here for all the participants, especially the contractors. We added this in the scenario because this is really what, from my experience, really what happens in projects is that the contractors wait until the last minute, for example, to present a global claim. And that's, I would say, a critical flaw. You know, like you should, as Engineer Amr mentioned, the defense when 20.2, I mean, if a contractor does not present the notice and the detailed particulars within the time of the contract, and the contractor is risking the response that Engineer Amr made. The contractor can lose his entitlement to an extension of time by just this simple defense that Engineer Amr made. So a contractor should really promptly present. In our case, the contractor lumped all the causes of delays and submitted an extension of time on the 10th of November, which is just more than 2 weeks before the completion date. I had a project, actually, Engineer Amr and I were in a project that the contractor submitted his extension of time claim the last one day, or maybe on the day of the completion date. So that's really a contractor should be very prompt in submitting this notification, because of course the engineer and the employer can take measures also to decide whether to, you know, they can prevent this delay from occurring from this variation or not. They can take some preventative measures. This is, of course, in addition to, that's why there's a time bar in the contract.
Thank you, Dr. Walid, for your additions.
Thank you.
The next question, Mr. John Shaker. Do any variation after contractual completion date result in an extension of time, even on a net theory? In some instances, the instruction is an omission for the scope or implementing late authority changes, which were identified at inspection at such late date solely due to the contractor's delay in obtaining authority inspections and approval for the handover. Do we need to look at criticality of the instruction as well for TOC? This can be directed to both respective speakers.
I will let Dr. Walid to answer to this question first, and I will add some more.
Of course, if the instruction is an omission of a scope, then that's really actually in the employer's favor. Yani I don't see that any problem at all, say, in this scenario, because yani it's an omission. So and if it's due to, as the question says, implementing late authority changes which were identified at inspections at such a late date solely due to the contractor's delay in obtaining authority inspections, of course, that part of the question is very important. And if the employer can prove that, then really what the employer is saying is that this delay, this variation is really due to your, directly caused by your delay, contractor. So you have, you were late in obtaining the authority inspections, and that's what led to the variation. I think that's a strong, it's a strong defense from the employer that this is definitely, this variation actually is a contractor's delay in the first place. So that to me, that scenario, whether it's an omission or it's a that kind of variation, and that would definitely entitle the employer to apply damages. Just because, but you know, the case that we were considering was a bit less clear than that. It's a additional finishes that were required, completely not due to the contractor. And as Engineer Amr actually admitted in his presentation, he was actually, this variation came actually as a tactical point strategy because of the tenants. He has pressure from the tenants or the users of the mall. So he employed this variation tactic. But I hope I answered your question.
And frankly, I have no other words to what you said, Dr. Walid. Thanks a lot.
Mr. Omar Kamil, this is for Engineer Amr. Engineer Amr highlighted that the actual damage due to delay of the completion caused by the contractor, which includes but is not limited to salaries for hired personnel to operate the mall, marketing team, and prospective profit for opening on New Year. These costs that the employer endured, aren't they considered consequential damages, which according to the contract cannot be applied as penalties on the contractor?
Look, I understand your question here. I have located this part that's for paying that the claimant, Dr. Walid, was saying that due to this late variation, this may mean that the employer has not suffered any losses. I have located this part to support and uphold my words that I really suffered for paying that all of this are losses. And for sure, the liquidated damages is a pre-estimate. And the prudent employer shall make a calculation before locating the ceiling and the day rate or weekly rate for the liquidated damages. Do you want to have anything here, Dr. Oli?
Yeah, I just want to add that this is actually a very good question, but we have to distinguish between two things. You're absolutely right. These are considered consequential losses. However, they were raised as a defense by Muhandis Amr, not as like a consequential damages thing, but as he just mentioned, as a defense against a loss. So he's saying that I did incur a loss. Who said I did not incur a loss? And therefore, the Article 224 that the contractor raised would not be applicable. Of course, طبعا we could have gone forever in this webinar and in this presentation, because each one of us has also responses to the other's arguments. Yeah. But you can say that the main point was not these losses, but the other. Did he suffer a loss because of not? Because he remembered about the variation, or he instructed the variation in February. On the 28th of November, this essential piece of work was not there. So he was still need to have these finishes done. طبعا, notice something. This is a way out also for employers who want to apply damages. One simple thing that would happen simply if you want to apply, the employer issues the TOC and makes another contractor do the finishing work. Yes. That would really be a supportive thing to apply damages in this case. That's what I wanted to clarify.
Yes, and frankly, it was one of Dr. Walid advices, I guess, 5 years ago, to one of the employers when he was asking to make a critical variation order after the contractual completion date. I remember that. Dr. Walid and Mahmoud Saadani, may I say one word for the gross and net method? It will be also useful. May I?
Sure.
Okay.
Yes, sure.
I want to say, look, in sometimes the impact of both approaches, the gross and the net method, may be equal in some circumstances. When considering the ceiling cap of the application of the liquidated damages is stipulated under some of the institutional contract form, like the FIDIC, if the contract data is include a ceiling or something like that, which it is capped, measured as a percentage of the final contract price. However, this provision is not existed in the GCT or the NEC. Okay, for that I'm saying maybe in some circumstances applying the net approach and the gross approach will have already a ceiling as a contract, maybe 10% or something like that. Okay.
Okay. Mr. Ahmed Abeid asks both respectful speakers, what about concurrent delays? How can be examined in both approaches?
I think in this in this case, there was not really a case of concurrent delays. So first of all, if you have concurrent delays, that's a totally different webinar, totally different topic. If at the contractual completion date of 28th of November, there were delays attributable to both the employer and the contractor, which effectively affected the critical path, that's another story altogether. However, in the case of net and gross, really what the dominant thing is that there was a clear contractor delay. So there's no doubt that the contractor is late in progress, and the employer orders a variation at the end. Of course, if there is a concurrent delay situation, then in that case, that's another story. The employer cannot apply damages, and then but this takes us to another field. That's my answer.
I'm agreeing with Dr. Walid. This question will divert us to another field. Okay, but I will add only something in the concurrent delay. The time for the employer delay will be added to the contract completion date also. Okay.
Bashmans Mahmoud, there was a question that had 4 votes by Muhandis Hussam Sami about the cornerstone, which method to apply.
Mr. Hussam Sami is asking, sorry, because there is.
Yeah.
Question number 1, this one.
Which method to apply is according to the variation? I think that's the cornerstone. If the variation is minor and didn't affect the work progress of the contractor, we can apply the net method. If the variation is major, we can apply the gross method. It according to the variation type.
Yeah, I just want to comment best on this. The question mentions the words minor and major. So the question that imposes itself on the question is, so who decides what's minor and what's major?
Yes.
This is going to be a debatable topic. The employer, for him, it's like حاجة بسيطة, it's minor. For the contractor, it's major. That's why it's something. I want to mention something very important. The solution, يا جماعة, to all this problem is very simple. In the contract, there should be a clause that addresses the issue of variations after the completion date. If there is a clause that discusses variations after the completion date and says exactly what to happen, in that case, the issue of prospective certainty is solved. The contractor knows what is going to happen, and the employer knows what's going to happen. Everyone's going to be happy. The contractor cannot object, because the contract would have said that any late variations ordered after the contract completion date will be processed in accordance with the Society of Construction Law, for example, that Engineer Amr mentioned. If that's the case, then really that's it solves everything. And hatta we don't even have to go into what's minor and what's major. But the problem that happens in our projects, and really that's causing this debate, is that it's not mentioned in the contract. The owner does not issue the variation order on time, because the contractor needs to know what's going to happen. So the contractor is left in the dark. And then, we have projects which that actually the contractor does not know for months. So that the contractual completion date has lapsed for months, 6 months, 7 months. The contractor submits several extensions of time claims, and no response is issued to the contractor. And the employer actually believes that I can at any time I can apply damages. But that's really problematic. And that actually takes us to the question of concurrent delays, because what happens by this big lapse of time, that then by that time you may have some concurrent delays, and there could be delays from the employer that have arisen after the completion date, not just a small variation, but some substantial delays. And the contractor can prove that the employer had not suffered any loss, so the employer is really taking a risk. But if it's so clear in the contract from the beginning, so for example, imagine the contract defines the net method, the gross method, and says that any late variation would be processed as such, and that's really, everyone is clear, it's the intent of the parties, and that would solve really all the problems.
I have no other words to say to Dr. Walid detailed clarification.
I think we can conclude now.
You will make the determination now? You will make the determination now?
Objection.
Order.
And I'm sorry, I acted as an employer. I was.
It's okay.
Okay, I would like to thank you, thank the speakers for such a beneficial webinar. And also I would like to thank CRCICA and the team and the effort spent and the platform so that we can broadcast such beneficial webinar. Thank you all, respectful speakers, Dr. Walid, Mr. Amr. Thank you.
Thank you very much. Thank you all. Thank you, Professor Mahmoud.
Thank you. شكرا لحضرتك يا دكتور وليد وشكرا لحضرتك يا باشمهندس محمود. شكرا.
شكرا يا جماعة. Thank you.
شكرا.
السلام عليكم.
سلام.
Salam.